Good morning, Your Honor. Jessica Richmond on behalf of Mr. Granke, who's present on the Zoom platform. Mr. Granke has supplied a declaration in this case. I think it addresses all points. And unless there are any new allegations raised by the respondents, I don't know that we need to take any testimony. Would the court be satisfied with just a recap of the declarations filed in this matter?
That would be fine, if you'd like to do that. One question, though, I do have is the incident talked about in the declarations from February 26th. That ground has been covered fairly thoroughly by the declarations by your clients, as well as what was in the original petition. I know the respondents here also provided in their petition information covering that incident pretty thoroughly, as well as the police report. So I feel I have a good sense of the February 26th incident. What I am primarily looking for is any testimony placing the February 26th incident into a larger pattern of behavior, rather than, as I said at the beginning, a single incident rarely qualifies for unlawful harassment. So if there's any testimony that, and this is going to both sides, that places the February 26th incident into a larger pattern of behavior, that's really what I'm curious about. So I'll go from there.
Okay, well, I think this single act of assault is enough, but if Mr. Granke, he's sworn in, if we could make inquiry with Mr. Granke in regards to their attempts to have Ms. Bristow and her mother leave their property on the 26th, that was triggered a call regarding some trespass allegations.
Okay. Mr. Granke, you are sworn in. So if there's anything further that you'd like to testify about with respect to a pattern of behavior against the respondents in this case, the floor is yours.
So the first day when I asked them to leave the property and they got very hostile with me, because
you say the first day, what are you talking about?
I think it was like the week before the assault happened. I had called the cops because they, were just being blatantly rude and, just coming onto the property, and I told them that I felt like they were encroaching on our side just to push us out of the house faster. And I talked to the cops that day, and they told me that they will give her information and say that she needed 48-hour notice in order to come over, which she would send to Destiny Ellis. And they waited a day and then came back the second day to continue that work, even without receiving any information that they were coming over again. And so
this is to do yard work?
That's what they claim, yes.
What are you saying has happened?
I mean, it just felt like they were on the property to try and motivate us to act faster and leave sooner so that they could have the property again.
What made you feel that that was the intent?
Because every time that I asked them if they could just come back or not go through our backyard to hold a wire from property over our back fence that was gated to use the weed whackers and everything. And it was just more so anytime that I asked them, they immediately got hostile. And I believe the first day, Bobby Bristow was the one to call the police that I talked to about the whole 48-hour notice. She immediately called them, trying to paint me as the bad person in this to make things worse. And then the second thing that I also put in the case as well is Felicia Bristow does have a history of shoving people and then immediately crying, because my fiance Destiny, her elderly mother was answering the door to Felicia, and Felicia wanted in the property and shoved Miss Ellis's mom to try and get in the house, and then she immediately started crying because she didn't want to get in trouble.
All right, thank you, Mr. Granke. Ms. Ellis, is there anything you'd like to add?
It's basically the same. It's just there had been a history of them entering our fenced backyard without asking. And it had just become an issue of, not just letting us know and just showing up and assuming because they were the landowners that they had the right to be there without asking us first. And then there was also the issue of them saying in court that they had gone to my fiance's work several times to try and serve him papers on their own. And I, feel like that wasn't appropriate to just continually show up at his work and ask his employer for his address, which they legally cannot give out. And there had been attempts to contact my family members to ask for our address as well, even though we weren't comfortable giving that out at the time.
Anything else?
They were also trying to reach out to her family using her father's ashes as bait to get them to answer. Miss Bobby Bristow is the one that was reaching out and using the ashes.
Well, to the extent that there are allegations involving Bobby Bristow, she's not a party in either of these. So I understand she's the mother of one of the respondents, but and her role as landlord and property owner is sort of bound up in a lot of the allegations here. But to the extent allegations specifically reference her, that's not something I can consider since she's not a party here. All right, so I'm going to turn it over next to Ms. Bristow and Mr. Chamberlain. If the two of you would like to raise your right hands. Do each of you swear or affirm testimony you're about to provide today is the truth and the whole truth?
Yes, Your Honor.
Okay. Go ahead, who'd ever like to speak first. And I guess, sorry, before you get going to comments that I made to Ms. Ellis and Mr. Granke, similar for you as well. I think the February 26th incident has been well traveled at this point. I've read everything a couple of times. So I'm really looking for testimony that places that incident into a larger pattern of behavior of unlawful harassment.
Can I respond to the last point made real quick?
Yeah, I mean, this floor is yours.
The box of ashes, it's a sealed box of ashes with her dad or grandpa's ashes in it.
It wasn't
And-
used as bait. We were just
No, we
simply
wanted-
trying to give it
It was
back.
left behind in a box of trash. We thought that was not right. Go ahead.
Again, that's something that my mother was dealing with, not us. And the incident that they spoke of on the 19th, neither one of us has entered their backyard or been anywhere near their backyard. My mother passed an extension cord over the fence through their backyard to plug into my building, but that wasn't us. And this claim that we were trying to get them to vacate earlier, they gave us notice.
They gave us a 20-day notice.
They gave us their 20-day notice that they were vacating.
So we were trying to
We
get
weren't
the
trying to
yard
push them out. We were just
ready.
doing yard work, and the property is a shared address. It's one property and I live there. It's my property
If I
as well
remember
as it
correctly,
is their property.
it is, if I remember correctly, it is one property. There's a residence.
Yes, there is
that's
a main house
that's rented out, that at the time was rented out by Miss Ellis
and Mr.
and
Granke.
Mr. Granke.
Well, no,
Maybe,
technically
right,
it was
right.
not rented to Mr.
Right.
Granke. He is not a tenant.
Right.
He has never been on the lease.
Right,
Him
understood. But I'm just trying to get a sense
supposedly
of who.
living there for
Right.
the last 3 years is.
Understood. The two of
Not
you
right.
live on the property as well. And
Yes.
is it a mother-in-law unit?
Yes,
Yeah.
it is
Yeah,
a
okay.
detached mother-in-law
Okay.
building.
Okay, and then your mother, Bobby, is the property owner and the homeowner.
Yes.
Okay, and the landlord. Okay,
Yes.
thank you. All right, I wanted to just That's what I recall from.
But the area of the yard that we were working on was a communal garden space in the front yard.
which we've had permission in the past to use. And we just never did it. But now the
And
landlord is with us and
it
we're
needed
just
fixing
making
up.
it look nice.
So we
And
were out
no
there
attempts
fixing
to
it
go
up.
inside. And in terms of, you know, the reference of Felicia pushing her mom or grandma in the past, what I was told is that
That's a
this,
completely
yeah,
separate incident.
but they're trying to set,
And there was never a police report. There was never anything. That specific
were draining the
incident that they
septic
were
tank.
talking about, we had permission to be in their backyard because we were dealing with a flooded drain field and septic issues.
and she was trying to
And
help her mom by going
My
inside to
mom
check the
told
toilet.
me,
So you are both able to testify, that's fine. For the record, it's gonna be difficult if you're both
Yeah.
talking at the same time.
sorry,
It's okay. So if one of you wants to sort of address it at a time, and then maybe the other can fill in the gaps, something like that, just so the record's clear on who's
well,
speaking.
I was there, so,
Okay.
okay.
Go ahead.
So the specific incident that they're talking about, we had a flooded drain field and septic, and they were pre-notified that we were there working on said septic and that we would need access to the house to test the drain lines and stuff coming from the bathroom and the toilet. And my mother told me, hey, go check the toilet. I knocked on the door. Her grandmother answered, and her grandmother pushed me off the step of the front door and said, no. And I said, I don't know why you're pushing me. I was told to come inside. She said, what do you need? I told her what I needed, and I walked away. So I don't know where they're getting that I pushed her, because that's just not true at all.
Thank you.
And regardless of that, it's hearsay. It's hearsay, because there are no police reports and there are no witness statements, and it was resolved between me and her grandmother.
Yeah, I understood.
So
Well,
saying
and
that
just
as,
more of a educational piece. I understand what you're saying, and I also understand that Miss Ellis's grandmother's not a party here either. Just this is for everyone, also the non-parties here as well. Hearsay is allowed in these hearings. The court is able to take hearsay evidence into account. But point taken on sort of the context that you're providing us in. Okay, thank you. Anything?
And then as
yeah.
for like an instance of repeat harassment, like there was the incident on the 19th, and then there were incidences afterwards, like when me and my mother had climbed on the roof of the house and were splitting Moss Killer, and he verbally attacked me for moving their trash can out of the way. Like it's like every little thing that we do to try and make the property and the houses look nice on the outside of the buildings with no request to enter the dwelling, they view it as harassment.
And if I remember correctly from last week, they've moved out. Is that
They
right?
have moved
They've
out,
Okay.
yes.
All right. Okay, thank you. Anything further from either of you?
I don't believe so, not at this moment.
All right. Well, I did say in the opening that I let petitioners sort of have the last word. Each of you are the petitioners in one of your cases. So I suppose I'll let each side take a few more minutes, or a few more moments rather, if there's any concluding remarks you'd like to make. So I'll turn back to Ms. Ellis and Mr. Granke, or Ms. Ritzman, if there's any concluding remarks you'd like to make.
Yeah, so in terms of the thing they're saying, the Moss Killer, I did not speak to them. I basically just asked them, can you tell us next time that you're using Moss Killer, because it's not safe for animals and we have 4 cats. And they spread it not only on the roof, but on the driveway, and moved all of the garbage cans out of the way without asking for permission. They just did it because they assume, since Miss Bobby Bristow owns the property, that they can just come over whenever they want. And we weren't home, and they wait until we aren't home in order to come over and do these quote inspections or yard work, as they say. I also wanted stated too that Um, sorry, yeah, go ahead. You go first.
And also in terms of the moving out and leaving stuff behind, you know, we were moving out under duress. Even though we had given a written notice, we were never served an eviction. And it just continued to get more and more hostile, both over text message and in person. And so we kind of just grabbed everything that we could fit into our cars and left because it was just scary and we were both anxious and not sleeping and not eating. So anything that was accidentally left behind was not on purpose. It was not because we wanted to just throw stuff away. And then we were told we could not return to get that stuff because we would be trespassed.
And I remember what I was gonna say now too. At no point did they, or did we or they agree that there was a shared communal garden. They came over one day saying they were gonna build a greenhouse, and if Destiny's mom could water everything and take care of it. And when they said no, because it's not our responsibility, because we didn't want it in the first place, they just did it anyway, and then they left it, and so it just decomposed right there on the grass.
And at no point in the lease is it mentioned that the yard is shared.
All right,
There-
thank you
There
both.
is a fence bordering almost all of it, except for the trailer that they put right there. And then suddenly, when they started parking their car, the last week before we moved.
Okay, thank you. Ms. Ritzman, anything further you'd like to say?
We're ready for closing remarks, Your Honor.
And sorry, just to be, we're, if there are any closing remarks that you have, now's your time.
Yeah, thank you, Your Honor. I think it's really clear that Mr. Grenke's original petition, that of Mr. Grenke and Miss Ellis against Miss Bristow and Mr. Chamberlain, should be granted at minimum against Miss Bristow, who has gone well beyond what would be required to establish harassment in this matter. It sounds like a lot of this started as simply a misunderstanding as to what access a landlord and her agent might have as far as entering the property without proper notice, climbing onto the roof without proper notice, and so on. But it's equally clear that Mr. Grenke, who is understanding landlord-tenant law correctly, made clear to them that they did require notice before entering the premises to include his yard space. And yet they continued to go on and do that. Miss Bristow acknowledges that they're just showing up to do work on the property. But again, without that notice, it was considered harassment by Mr. Grenke and Miss Ellis. Mr. Grenke, though, takes this one step farther with the allegations of assault. And so even if that landlord-tenant dispute didn't establish harassment on its own, although I think it does, a single act of violence or threat of violence is enough for this order to enter. And it's easy to see that that assault by Miss Bristow on Mr. Grenke did in fact occur. And you can see that not just with his declarations, but with Miss Bristow's. Mr. Grenke, in his declaration, tells the court that Miss Bristow is there ripping open bags, throwing the contents of garbage bags on the ground in his direction. During that, what turned into a verbal dispute over it, he felt someone shove me on my shoulder and back, and then Miss Bristow's partner, Josiah, came running up the driveway and screamed, "You're lucky the police are coming or I'd beat your fucking ass." So very clearly a hostile and frightening environment for Mr. Grenke, who was first assaulted by Miss Bristow and then threatened by her partner. His statements are supported by Ms. Landry's declaration. wherein she was on the phone with the kids during this altercation and overheard Miss Bristow defending the push by saying only, "I lightly pushed him," acknowledging the assault. And then with Miss Ellis's statements, we know that this did in fact happen because it's in her statements and the police reports that she was defending it as simply putting her hands out to avoid the fall. So we know that that contact did occur. It's supported by Miss Ellis and Miss Granke that it was a deliberate assault. Miss Ellis has in her declaration indicated that she saw her push him with both hands. And that, of course, that assault is enough to establish that a single act of violence did occur. She defends this by saying that.
Ms. Ritzman, I apologize to interrupt real quick. Ms. McConaughey, you're welcome to stay in the courtroom, but you're going to have to keep your voice down while others are speaking. If you'd like to talk about your case there with Ms. Busha, you
trying to talk about my case with you.
right, but we're hearing another case right now, and we can all hear you talking, and so while this other case is going, you either need to keep it down or you'll need to take it outside.
No, I don't have a problem.
All right. Okay, thank you, ma'am. Go ahead, Ms. Ritzman.
Okay, so we have Mr. Granke's petition and declarations alleging the assault and the ongoing harassment. And by way of response, it isn't really a response to this petition, but instead the counter petition by Ms. Bristow justifying the assault to law enforcement by saying that she was just bracing herself, indicating that the throwing the bags was by Mr. Granke, not by her, and claiming that she was somehow the victim. But her counter petition, well, in some ways is a response to the allegations. It mostly just acknowledges that these acts did in fact occur. She admits to making contact with Mr. Granke. She admits that there was a dispute over the trash. She talks about how lining the trash up, taking it out to the curb was apparently an inconvenience to her that she considers harassment where it's not. These allegations of the assault and the ongoing harassment are well established by Mr. Granke and effectively acknowledged by Ms. Bristow, who admits encroachment on their tenancy on more than one occasion without proper notice, seemingly thinking that that is appropriate, though Mr. Granke had more than once asked them to stop doing that, and then acknowledges that single act of assault by reframing it in her response. There's more than enough here to enter an order protecting Mr. Granke and probably Miss Ellis from any future acts by Miss Bristow. Admittedly, the allegations against Mr. Chamberlain aren't nearly as strong. It's a single threat of violence, which may not be enough under the definitions of 1C, clearly would meet the definitions under 2C. As far as that threat, it clearly did harass, annoy, and alarm Mr. Granke, but most importantly, that order should be entered against Miss Bristow. It's more than established.
Okay. All right, thank you. And so for Ms. Bristow and Mr. Chamberlain, it's your opportunity for concluding remarks.
Your Honor, to call it assault at all feels like a punch to the gut, because I was very clear and very honest in my witness testimony and to the police in the police report that I did not push him. I did make contact with him because he was throwing trash at me and I fell. I tripped over the bags and I fell into him. So,
I've been worried to
And-
go to work because the pattern I notice is that he only really confronts these two when, say, myself isn't home. Like this, every time an instance is started, it's been while another man wasn't present. So I've been worried to go to work.
and then for them to say that they're worried about me because of that, when the only reason I made contact with him is because he was throwing trash at me, which he doesn't, in his declaration, he doesn't say that he ever did touch the trash, but in the police report, he claims that the trash was moved in like a back and forth fashion where he did move the trash and was throwing the trash at me. So his statements, they continue to change.
In terms of credibility, during one of the initial police visits, he tried to say that he only lived there for 2 months, and then Destiny couldn't even get it straight with him, saying that it was 3 years, and now it's changed to 3 years. They've changed my wording on the quote unquote threat.
Which I also don't think that's a threat, because he wasn't threatening that he would beat their ass. He was informing them
I
that they
won't.
were lucky that he won't, as in he is the bigger person who would never consider
In terms of me walking up to them, it was for me to confront him and ask
why he was
what
throwing
happened and why he
trash.
was throwing trash.
All right.
Because I got home after the bag was thrown at my wife's feet, and then she fell into him because of, and then her hands made contact with his shoulder as she was bracing for the fall, and he stepped out of the way and let her fall.
Which the cop verifies that I continued to fall, and I have indentations on my hands from the asphalt. So it was in no way a malicious assault. That
We have
is
no,
incorrect.
we don't want to see
And
them
to say that
again.
I was ripping bags open and throwing trash all over the place, the cop again notes that there are multiple bags and that none of them have any holes in them, except for one bag had a small fist-sized hole in it, but that there was no trash spread all over the ground or thrown about, or that I was creating this huge commotion that I wasn't.
He says he has chronic back pain, but he's moving these bags and big rocks a lot.
Like
Thank you.
their
So,
statements just don't corroborate themselves.
We have pictures
Do we have-
showing the blockade
Right.
behind my car before I moved it
yeah,
out.
do you have any concluding remarks outside of that incident?
No.
All right, thank you all. So, first of all, I appreciate everyone being here a couple of times. I know the matter was continued out a few times, and both sides have submitted a number of declarations and documents. So I know everyone put a lot of work into this, and feel strongly about the outcome. I'm going to deny all orders, essentially, and I want to start with the issue of single act of violence. And so I want to be clear, and I'm just going to read the definition for a single act to qualify as lawful harassment. I'm just going to read it out. Single act of violence or threat to qualify needs to be directed at a specific person that seriously alarms, annoys, harasses, or is detrimental, and that serves no legitimate or lawful purpose, which would cause a reasonable person to suffer substantial emotional distress, must actually cause substantial emotional distress. Here's the critical part, though. A single threat of violence must include one of these two things: either malicious and intentional threat as described in a separate statute. That separate statute, RCW 9A36080-1C, is a hate crime. So it needs to involve a hate crime, which is a threat against a specific person or groups of people because of their inclusion in some sort of protected class, or in the presence of a firearm or another weapon. So whether or not an assault occurred or did not occur, the Lacey police officer who responded clearly felt that it was at least not probable cause for an assault. But even if there was, an assault by itself does not qualify for a single act of violence under the unlawful harassment statute. Again, that needs to be done in the presence of a firearm or other weapon, or needs to be a hate crime. And I don't find that either of those situations qualify in this particular case. In either direction. The February 29th, or I'm sorry, February 26th incident simply didn't involve a hate crime or involve the presence of a firearm or other weapon. To the extent that there are allegations outside of February 26th, with, I'll address particularly issues of kind of landlord-tenant issues or allegations that at this point, just Felicia Bristow, but also in some instances, her mother, who's not a party here, coming on to sort of the tenant part of the property. First of all, that's not, there's testimony to that, of course, and some exhibits to that effect. The petition is grounded really in the February 26th incident. To the extent there's allegations that there's harassment because of Miss Bristow coming on to the tenant part of the property, I don't find that the burden's been met, that meets the definition of unlawful harassment. First of all, is if if there's disputed issues on where property is shared, where it's not, that's a real property dispute. The district court doesn't have any jurisdiction to decide. If there's issues on what areas of a property are shared, what aren't, what's burdened by some kind of easement, what's not, where is a property line, that's all. Those are disputes that get resolved in superior court. That's not, district court doesn't handle those issues. And to the extent that Miss Bristow was maybe going on to areas that of Miss Ellis's area or Mr. Granke's area to do yard work or some other things of that extent without notice. If there had been technical violations of the Landlord Tenant Act, I don't think there's anything before me indicating that kind of violation, even if proven, again, necessarily triggers the unlawful harassment statute as well. I think there needs to be more of a showing. I also think there needs to be a showing of who was even on the lease, who was coming onto the property. There's a lot of missing pieces to that, those allegations before you get to unlawful harassment. So, to conclude, I find that neither of the petitions meets the elements for unlawful harassment. And so going forward, this is not a reason for the denial. It sounds like Miss Ellis and Mr. Granke have moved to a different location. So hopefully you don't need court involvement for the parties here to not interact going forward. But to the extent these allegations claim previous unlawful harassment, I'm denying those claims and denying all the orders. So there was a temporary protection order in favor of Miss Ellis and Mr. Granke. That will be rescinded. And so there's no more orders in place going forward.
Thank you.
Do you have any questions here in the courtroom?
No.
Miss Ellis, Mr. Granke, any questions?
Not right at this moment.
Okay. And Ms. Ritzman, any questions?
Just to be clear, Your Honor, Your Honor had called the first case in time when we started this matter without addressing the second companion counter petition. So we didn't touch on those issues specifically, but am I clear that both petition and the counter petition are addressed with the single hearing and both orders are denied?
You are correct. And yeah, I suppose I could have been a bit clearer. When there's cross petitions, given the informality of these types of proceedings, when there are cross petitions, particularly cross petitions that are grounded in essentially the same allegations, we hear them concurrently. And so yes, matter ending in 6-8 with Ms. Bristow as the petitioner, Mr. Granke as the respondent, that is being denied as well.
Thank you, Your Honor.
Thank you, Ms. Ritzman. All right, so nothing further anyone needs to do, nothing further you need to file or anything like that. We will email and send around folks copies of the denial orders, which I'll sign later today.
I just had a quick question.
Yeah. Yep, go ahead.
Is there a way that my father's ashes could just be given to the police and I could pick them up so we don't have to interact? because they weren't left behind on purpose and I'm having issues getting those back.
At this point, the court's not involved. And so there's no orders. If you all want to work out a way to get the ashes back to each other, be careful. Obviously, there's some ill will here, but that's going to be something y'all have to work out on your own. The court's not going to get involved. All right. Thank
Your
you.
Honor, can I verbally address that and inform Ms. Ellis that we will not be responding to any
Okay, so we're not,
that
we
she's
don't do
coming
that here.
towards us?
Yeah,
Okay.
you're all going to have to work this out on your own.
Thank you very much.
All
Your
right.
Honor.
Thank you all.